Program. I am the Dean of the University of Maine School of Law, and I'm very proud to welcome back Betsy Boardman. She was the graduation speaker last year, SBA president. She's also been active in our juvenile justice clinic. She was the intern, and I think that's what led her to Kids Legal, representing the interests of the most vulnerable people in our society. I will leave the formal introduction to Sarah LeMay, but I just wanted all of you, especially first years, to recognize a graduate of the University of Maine School of Law, a very proud graduate. Thank you.
So I just wanted to do a quick introduction of the Maine Juvenile Law Society, who is hosting this event in conjunction with CPJJ, the Child Protective and Juvenile Justice section of the Maine State Bar Association. The Maine Juvenile Law Society was founded at the close of my second year, close of last year. And the purpose of the Maine Juvenile Law Society is to bring to the front issues specifically of juvenile justice in Maine. So restorative justice, rehabilitation, and things that are really specific to juveniles who come into contact with the criminal justice system, because those issues are substantially and significantly different than the issues faced by adults who come into contact with the criminal justice system. So we have Betsy here with us today to give a presentation about education and the law. There is a little bit of a misconception, I think, that education law is strictly just for those who practice education law. Education law is for anyone who really works with kids. So Betsy is a special advocate with Kids Legal, and she focuses on education matters, including special education, which is personally close to my heart. Special education identification and programming, and access to education. And various enrollment issues that students face. She is, as Dean Conway said, a recent graduate from Maine Law last year. While she was here, she was an advocate, and are you still a CASA advocate? She was a CASA while she was here, and she remains a CASA. She was in a juvenile justice clinic, and prior to law school, Betsy obtained her master's in education from Hood College, worked in education for 10 years, and obtained her bachelor's degree from Washington and Lee University in Lexington, Virginia. Sorry, I'm reading so much from the paper. And also with us today is Courtney Beer. She is the directing attorney for Kids Legal.
She's my boss.
Yeah, she.
Right? So everybody has to ooh and ah.
She's kind of a big deal. Kids Legal is a statewide project within Pine Tree's Legal Assistance, and it focuses on the rights of minors. Courtney began her legal career in 2007 as a Coffin Fellow with Pine Tree. She represented victims of domestic violence and sexual assault in divorce, parental rights, and protection from abuse matters. And in the interest of time, no offense, Courtney, I'm going to cut your bio a little bit short.
I'm here as a CPJJ member today.
She is here as a CPJJ member today to support Betsy, and maybe if you all have any questions afterwards. So with that, I'm going to turn it over to Betsy, and I hope you all enjoy.
So glad to be back. So glad to still recognize so many people. If I do this next year, it's just going to slowly dwindle down and down and down. But so glad to see you guys. So as Sarah said, I am a fellow at Kids Legal, which is, excuse me, part of Pine Tree Legal Assistance. Pine Tree as a whole represents families, children, and a variety of civil and educational issues. We consult with parents, attorneys, advocates, so part of what I do is consulting with other professionals, working with children regarding the rights of children. We prioritize school issues that affect education, including enrollment, special education, truancy, disciplines. We're looking at suspensions, expulsions. We also identify and provide assistance with other legal issues affecting the basic needs of the family and child. So we also have a lead paint program, which is based out of Lewiston. So that's specifically working with families who children have elevated lead levels, which result in behavior issues or other issues. Okay, so the big starting point is what law is governing education law? So you have a federal law, which is the Individuals with Disability Education Act, IDEA. That was enacted in 1975. It's been revised a couple of times. And that covers kiddos from birth to age 20. State specific, we have MUSER, which is the Maine Unified Special Education Regulations. This is kind of Maine's way of enforcing IDEA. FERPA, Family Educational Rights and Privacy Act, that's why we have to fill out 100 different releases to get these kiddos' records. And education generally is Title 20A. So, it's really simple what we're going to do today. We're going to do the how, and we're going to do, or why, and then the how. So why is this important? Why is special education important to people who are working with kids? So we start with some typical juvenile issues. I also really love clip art, so bear with me. Interestingly enough, I was like, what would happen if I looked for clip art for Betsy? A bunch of women sewing flags. So. Homelessness, juvenile justice system, which is a lot of the work that they do over at the clinic. Anybody here interested in doing guardian ad litem work? Education barriers, so expulsions, programming. All right, why? Why is education important to homeless and unaccompanied children? Now, this is going to kind of tie into the guardian ad litem, foster, and when I'm talking about guardian ad litem work, I'm talking about in the foster care system, not necessarily in the family law context. So these two are going to be pretty closely related. Limiting the number of educational transitions for kids is really important. Limiting that number has shown to have better academic performance for kids and overall better educational outcomes. Different residency requirements for homeless students make accessing education easier. And I say easier because nothing is really easy for these kids at this point. But whatever we can make easier for them, the better. Laws are designed to provide much needed stability. So what laws are we talking about? McKinney-Vento. McKinney-Vento is what you turn to when you have a homeless child, when you're facing enrollment issues with school. Okay? So definition of a homeless child, lacking a regular, fixed, adequate nighttime residence. The minute this child starts couch surfing, homeless. Enrollment options. So the child can choose where they'd like to attend school. They can attend school in their original school district, so where they came from, or if they've moved to a different school district, they can enroll in that school district. What does the school have to do? Immediately enroll this child. No need for records. They also have to provide transportation. This is the same rule for foster children. Speaking of foster children, why is special education law important to GAL? This is the sad part, okay, but we'll go fast. Children in foster care system twice as likely to be absent from school than other students. More likely to experience multiple school changes. Twice as likely to receive out-of-school suspensions. 3 times more likely to be expelled than other students. Those who are identified as special education students tend to be placed in more restrictive educational settings. They also, once they are identified, the plans that are required to be put in place after a child is identified as a child with special needs take exponentially longer than children who are in foster care. So, as a guardian, this is stuff to keep your eye on. This results in children in foster care score lower than their peers on standardized tests. Poor quality education plans and delaying implementation can cause academic deficiencies and knowledge gaps. This is really sad. Only 50% of foster youth across the country complete high school by age 18. 50%. So, near and dear to a lot of people's hearts, why is this important for the juvenile justice system? So when I was working at the clinic, I worked out these great deferrals and dispositions for these kids, and part of that was always attending school. So you need to know about special education in order to get, be able to identify these kids. Some of the charges occurred in school. Unfortunately, we're seeing more and more of that. Detained children, ooh, they're entitled to an education, including any special education services that they qualified for prior to being detained. Actions of the juveniles may be attributable to their disability. And we're going to get into this a little bit more. Special education form developed can help facilitate appropriate interactions with a child. So I'm going to give you one example today, I promise. Well, I don't promise, but as of right now, it's one example. I had an education client of mine who ran into some trouble with the law and actually ran to our office. And upon the police arriving, a coworker of mine brought, this child is diagnosed with some pretty significant special education needs. A coworker brought the police officer into the conference room. What is going on? This is brilliant. He explained to the police officer this child's disability. Explained to him how he processes things. Explained to him how he needed to explain things to this child. So the police officer came out, and instead of things immediately escalating with this child, like things tend to, he approached this child in the way that he needed to be approached. So knowing about a child's disabilities and special education needs can help you communicate with others in that child's world. School discipline. What simply looks like bad behavior may be a disability. If a child is diagnosed with a learning disability, any sort of special education services, additional due process rights come into play when discipline is being administered to that child. Children identified as special education students are entitled to services when they're suspended or expelled. He's so sad, but school discipline, a couple of different types. Detention, suspensions. Suspensions can happen a maximum of 10 days. Expulsions, that's when those extra due process protections come in. So if a child is suspended for 10 or more cumulative days, so you can get suspended for 2, then you can get suspended for 2, and then you can get suspended for 6, that's 10, right? That's when this kicks in. That's when the school has to hold a manifestation of termination. And what they're deciding there is this child's behavior due to the child's disability? If so, a couple of other questions are asked, and they do what's called a functional behavior assessment. Getting to the root of the problem, as opposed to saying, you're bad, see you in 10 days. How? Let's prove it. This is great. And also, too, if you guys have questions as we go along, I'm going to leave a little bit of time at the end for some questions. But if you have questions that you're just dying to ask, feel free to do that. I can say that now that I know we have enough time. Okay, how? So how, as somebody who advocates for kids, are you going to implement this? Remember the federal law? I've changed it a little, and we're going to identify, discuss, educate, and advocate. Identify. So this is a list of common things you see with kids. Common things that you look at a child and you think, oh, he's 8. That's what 8-year-olds do. It could possibly be a special education issue. So these are some things to look out for with your clients that if you see, rather than saying, oh, that's just, he's just 10, that's what they do at 10. You might want to say, I wonder if this is a special education issue. Absent or suspended more than 10 days. A lot of the kids that we see in our office are not going to school. So it's a truancy issue. And your first reaction might be, well, when I was 14, I had better things to do than go to school as well. But kids are often avoiding school because of a learning disability, because they are struggling so much in math class, struggling so much in reading, that's why they're avoiding school. Test grades show a weakness in one or more academic area. Issues relating to peers, school staff that result in negative school behavior, incidences. I have a kiddo that hides under her desk all the time because she's avoiding work because it's too hard for her. But at first it was she's having negative behavior she needs to be punished for. Previous evaluations that diagnose a child with ADHD, autism, PTSD, or other mental impairments. Some of these are actual things that you can get diagnosed with through special education. Others are just kind of incorporated in others. But those are red flags. Is the child's ADHD impacting, and kind of the big question is this child's disability impacting their access to education? So you can have a child in a classroom that has ADHD, doesn't impact their education. Very well managed, the child, doesn't have effect on their access to education. You can also have a child with ADHD that does have an impact on access to education. Organizational skills, remembering information, staying focused on tasks. And I have realized that with this job, I have to be careful when I look up some of the diagnoses of my kids. I'm like, totally have that. But these are also to the extreme on some levels. So, medical needs that may impact the way the child's education can be provided. Part of special education, what you're looking at, there's also a 504, which deals a lot with medical conditions. So if you have a child who's a diabetic and needs to miss a good amount of class every day to go get his sugar checked, there needs to be accommodations put in place so that child isn't, losing so much education every day. Hard time communicating. So if you're a guardian ad litem and you're working with an infant, if you're working with toddlers, you need to be looking for those benchmarks. So is the child talking when they're supposed to talk? Is the child rolling over when they're supposed to roll over? Those are all issues that the CDS gets involved with, but that later translates into the special education world. Oh, see, ahead of myself. Has the child been expelled from school without a plan for reentry? So when a child's expelled from school, there's two options. Either the child is expelled for an indefinite period of time with a reentry plan, which means the school board and the superintendent put together a list of things that the kiddo needs to do in order to go back to school. Or they're suspended for the equivalent of one school year. So if a child has been expelled, again, look into the special education issue. Are they having behavior issues at school due to, a specific learning disability? Okay, next step is to discuss. Now, the big disclaimer with all of this is you need to get the appropriate permission. Okay, you can't take information about your client and just go running and talking to everybody about it. So, that will be in here as well, but who? It depends. Who do you discuss this stuff? It depends. The juvenile justice issue, who's your client? the kid, right? So you've got to discuss it with the kid. Ask the child, how's school going? What's your attendance like? May I access your school records? Guardian, you talk to the foster parent. You talk to DHS. You can talk to the school directly. Now, DHS or the foster parent should be letting the school know that you're the guardian and therefore can have access to that. I have found that your order of appointment can get you through a lot of doors. So if you get an order of appointment, hold on to that. Homeless student, you need to talk to the student. Education school issue. So if you're having a programming issue, if you're having an expulsion, a suspension, that's when you need to talk to the parent or guardian. What are you going to talk about? What are you going to look for? Any evaluations that have been done? Educational records, so grades, progress reports, behavior incident reports. If the child's already identified as a child with special education needs, they have what's called an individualized education plan. That's an IEP. You're going to want to get a copy of that. See what services are in place for the kid already. See what services might be missing. Again, this is a lot. And I normally preface trainings by saying at the end of each slide, insert something that says, call me. Okay? This is, you know, education law is a whole separate kind of beast in terms of referring for special education services and that kind of thing. We are always here as a resource, so don't hesitate to call us. Educate. Chances are there's a lot of individuals in this child's life. So if you're doing juvenile justice work, you have a JCCO, you have possibly a caseworker, you have a ton of people in this child's life. These are all people with your client's permission that need to know what's going on with this child in terms of special education. Educate yourself. And again, be careful if you're anything like me. You're going to think you have all sorts of things. But educate yourself on what the diagnosis is, what it means for that child, how it impacts that child's daily life, how it impacts that child's interactions with others. Oh, this one spins. That means it's important. Get appropriate releases signed first. Advocate. So this is going to be your, kind of final step when you're working with kids. Use the information. Advocate for services for the child. Again, this is going to be a call me button. Okay. This is going to be both in school and both out of school. Do you need to write a de minimis motion? Include special education issues in there. If you have an autistic child that can't perceive other people's emotions and that resulted in criminal behavior, put it in motion. Talk about it in court filings. Yep, that's it. Refer to the case to the appropriate resources, which is all of those wonderful, wonderful people, including us. So that is it. We have questions. No.
I don't do much special ed work, but just as a practice tip, my perception has been that it's extremely important that you know everything you can find out about this kid. And you should be you should get every evaluation that you can get your hands on. Because when you get into those hearings or the meetings, the IEP meetings, you're always outnumbered, and they're always very kind of smug, because even though they say the fix isn't in, the fix is usually in. So to the extent that you can shake them up by saying, how about this evaluation? Did you know he has this? Did you know this history? That's really important. That gives you credibility and puts them on their heels. So, get every piece of paper you can, summarize it, have it at your fingertips, and be ready to leap in gently, to say, or however the meeting goes, but be ready to know as much as they do, and preferably more. So that's but I do have a question. 504 IDEA, you know, what are the criteria for either one, and why would you rather be in one than the other?
So this is kind of an age-old question, and I'm going to answer it as best as I can, and Courtney can jump into it if I'm not, you know, kind of accurately describing it. So 504 plan, it's usually set up in the school will do this, the child will do this, the family will do this. So you're talking about, most of the time a lot of the time it's medical issues, as I said, like diabetes, what is preventing this child from accessing education like the other children, as opposed to special education kids who have an IEP. Those are more, that individual child has some sort of limitation that needs to access his learning differently. 504 plans, those kiddos can access education just like everybody else, but there's some sort of barrier, whether it's having to leave for, as I said, sugar checks. IEP kids need special accommodations to learn differently. Would you say
But
that?
what are the criteria? I mean, how do you get identified? It's not easy necessarily to get identified
No.
as qualifying under IB.
Yeah,
right?
so there's a referral process. So schools are required under Child Find to refer children who they think have or possibly have a special education need. A parent can also refer. Anybody with knowledge of the child can refer a child for
So the
special
GAL can make the referral?
Yes. Yep. So after the referral is made, the school goes through the evaluation process. There's timelines attached to all of this, but they go through, do the evaluations, then you have a kind of determination meeting. Does this child qualify for special education services?
And the evaluator is always a big, I mean, selecting the evaluator can make a big difference in whether the assessment's done well, I mean, how do you go about working with the school or dealing with the school in terms of selecting an evaluator?
So the school selects the evaluators. They do the evaluations. You have some sort of control over what evaluations are done. So you can say, I think the child needs this evaluation. I think the child needs this one. And then if you get back kind of, I got an evaluation back once that was a page and a half. And I was like, what is this? You can request an independent educational evaluation. And that is also at the school's expense. So if you get back just an evaluation that doesn't tell you anything, you have the right to tell the school that you'd like an independent evaluation. You can then go choose whom you'd like get that done.
What's the criteria, or what are the criteria for actually being identified? What's
So
the standard?
It depends. It depends on what the different categories for being categorized as special needs. So there's other health impairment, there's autism, there's specific learning disability, there's emotional disturbance. The majority of those go on a eligibility is determined on a form that's an adverse effect form, which is basically a slew of questions that says, does this disability adversely affect the child's education? In 12 or 14 different question forms. Things like specific learning disabilities have their own forms, which require an overall processing disorder, a certain amount of standard deviations away, and so those are a little more specific, but it depends on the diagnosis that you're looking at.
I'm just going to jump in. Each eligibility category is defined by MUSER. So in MUSER, each category it will lay out for each category what it means to be disabled, and then if you qualify under the definition, you do have to go then to the adverse effect form. A child could qualify under the definition, but it may not have an adverse effect on their education. And so, as Betsy said, MUSER is a whole different beast and it's a whole different language, and so getting into the nitty-gritty is hard to do in this kind of form, but everything is defined there, and it's a big book, and it's not very easy to get through. It's a very cumbersome set of regs.
When you're looking at disciplinary proceedings, you said that there are certain special due process rights. Maybe can you just give a highlight of like some of the big ones?
Yeah, so a child who's identified as special education, If they have, as I said, been suspended 10 cumulative days throughout the school year for similar behavior, you have to hold a manifestation determination. That decides, everybody, the whole IEP team sits around the table, goes over the behavior, goes over the diagnoses, goes over, all suspected disabilities, some do, and determine if that behavior was a manifestation of the child's disability. Which, if the determination is yes, the next step is, was the IEP being followed? If that answer to that is yes, then they go on to a further step and say, okay, we need to do a functional behavior assessment. And what the functional behavior assessment is doing is looking at the child's behavior throughout the day, multiple days, and saying, what's triggering this child? What does the child look like when he's not escalated? What does the child look like when he starts to become escalated? What does the child look like when he is full throttle, to the walls, escalated? And then that will typically turn into a positive behavior plan, which, gives various options. Does the child need noise canceling headphones? Does he need to have a break every 15 minutes? So deals with the behavior at its root, as opposed to saying, non-special education kids, your behavior problem, you're not going to be in school. Hopefully you won't do it again.
And if a child is found to have it be related to their disability, they cannot be disciplined the same way that a child without that disability could be disciplined, and so that's why they're put on that track. If it's found not to be substantially related to their disability, or they're not a child who qualifies for special education protections, then they have a right to due process if they're going to be suspended over 10 days or expelled. And the right to due process at that point is a notice of the hearing and the actions brought against you and the charges or the reasons for the potential expulsion or long-term suspension, and then an opportunity to be heard. And that's all laid out in the safeguards that are provided at that stage. And so since a child is entitled to an education, they have a right to due process if that education is going to be compromised. Does that answer the question?
So I understand that when you're doing these special education and trying to advocate for the child, there's going to possibly be other instances and other legal proceedings that are occurring concurrently at the same time with, say, if there's an issue at home, possibly an abusive environment, or if they're not being able to have that security of housing. So I'm wondering, how do you navigate those multiple legal issues when you may only be advocating from the one perspective of the education?
Well, we call the clinic, have them deal with the juvenile issues. We typically just focus on the education issues. That's why I think if you're doing juvenile justice work, I think it's important that you reach out to these resources and say, how do I effectively advocate for this kid educationally? Is that answering your question?
Can I add to that? I mean, I think that was a really great question, and you're absolutely right. So a defense attorney is going to have to navigate that. So like an admission and an expulsion hearing could come back to implicate something that's happening in the juvenile court, having something on the record like that. So you're exactly right. That was really a great identifying issue.
So that's what, if you have a kiddo that you have another issue with, and all of a sudden you find out they have an expulsion hearing tomorrow, that's why you need to call somebody like kids to say, what do we do? We can just give you generic advice and say, if you're going to represent them, here's some advice. So yeah, because it is all connected, and that's kind of the point of this, is there's so many things that go on with these kids, and you need to be aware that this is one thing in their tiny little complicated worlds.
I've had cases referred to me by juvenile defense attorneys, and we'll sit at the table together at the IEP team meeting. The juvenile defense attorney and myself, we have the same goals, well, different goals, but we're advocating for this same child, obviously. And it really helps to kind of come together and address all of the needs holistically. And the part of the probation is usually attendance at school, and if they're not attending school for whatever reason, maybe they have anxiety that's preventing them from wanting to go to school, or depression issues, or learning disabilities, whatever it may be, if they can't actually get to school and access school, then they're not going to be able to comply with that part of the probation. So you'd be setting them up for failure ultimately. So unless we address those needs as a team, you're setting the kid up for something that they're not going to be able to succeed at from the outset. And so defense attorneys calling us, I really admire tremendously, because they're looking at the case holistically, and they're able to not assume that they can deal with those issues themselves, but they're bringing in people who have particular expertise in being able to do that. So it works really well. And we can also keep stay involved after the juvenile, there may be resolution to the juvenile case, where the juvenile defense attorney may no longer be involved.
Casey?
I'm not sure if you're going to be able to answer this, but I guess if there is a child that has a disability and they're acting out in class maybe every single day to where the teacher has to interrupt class for 10 minutes a day or 5 minutes a day, is there ever a certain point where the other students in the class kind of also have, right, and like not to sound ignorant or anything, but is there, I'm sure the parents of the other students might also start wondering what's going on, but I'm sure like their disability and privacy rights are also at play, so how, do you ever deal with like balancing the rights of the other kids that may be getting distracted?
So part of special education law is that the child's required to be in the least restrictive environment. And the goal is always to keep kids in mainstream. So kind of if you're looking at the LRE pyramid, your mainstream, full mainstream kid is kind of your least restrictive environment. Then you can have ed techs in with that child. You can have, then the, possibly getting school in the resource room. So the goal and what we're always advocating for is the least restrictive environment. I've never dealt with a parent calling to say there's a disruptive child in my child's classroom and it's affecting my child's education. There are strict privacy, because if a child comes home and says, Bobby Sue threw stuff and we need to leave the class again, if that parent contacts the school, they can't talk about Bobby Sue. So I personally have never dealt with that, but I do know that, kind of from the special education student perspective, we want that child to be in the least restrictive environment as possible. So that might mean that they need additional supports in the classroom. It might mean that that is a particular class that's hard, particularly hard for that child, and therefore they may need to be in the resource room, a special education teacher for that class. So normally it's either the parent of a special education child saying she's disrupting the class all the time, or the teacher saying she's disrupting the class, it's too much.
I was wondering, this is not a policy question. Do you guys think that teachers at the forefront, not necessarily special education, like who have a special degree, have enough curriculum when they're studying to be a teacher to be able to accurately notice these types of issues with kids? And if you don't think, do you guys ever do any policy advocating, trying to make it so there should be more curriculum? Because I know when I went to Farmington, I think that most general teachers only have to take one special education class in order to graduate. I'm not positive on that, but do you guys think they should have more? And if you do you advocate for that anywhere, policy-wise?
So we don't do actual policy work. We do kind of, if a systemic change is needed, we will advocate for that. Part of the child find requirement that they have is, a lot of it is on the administration in terms of any child that moves into the school district within 30 days needs to be evaluated for child find to see if that child might have a special education issue. That includes kindergartners. So I'm actually trying to think of the training that I had with my master's, and I think it was one class on special education. So yeah, I mean, if there was an under-identifying issue, that's something we would definitely advocate for. I don't think I can really make a comment on, because I don't know the individual, teaching that these teachers have had. But it is nice that there is some sort of accountability on the administrative level through the child fund.
And there are a lot of educational opportunities through the firms that represent the districts for teachers and administration, and I think it's a matter of having the district access those services that are, trainings that are available. I don't think that enough teachers have the trainings they need, and it's unfair to the teachers, quite frankly, that they don't quite understand what their obligations are, but then they're having to deal with children who they recognize as not thriving and succeeding in their classroom, but they're not donor support from the administration in some cases that they need to help that kid get services.
So foster children tend to jump around from house to house, can live in 5 or more households easily within a couple of years. This often leads to many behavioral problems that are often misdiagnosed as some of these disabilities. So, I mean, with these external problems that are happening in these kids' lives, what can we do to help, stem the problems of, instability in their living situations, misdiagnoses, and, finding ways to tell these kids that they are not disabled, if they aren't, but that they are, but that they're normal kids and they need to get to back to their normal lives. How can we, outside of the schools, help support foster parents who may be overburdened, overstressed, or just don't care about these kids' educational needs?
So I think that's an important place where the guardian ad litem comes in. My guardian ad litem case that I've had for 2 years now. Children have been in various placements, have been in various schools, and part of what I really advocated for these kids was keeping them in the same school unit as much as possible. I also have advocated with the foster families to, I had one child who needed a special education referral and didn't get it for 1.5 years until, it had to be pushed because they're having so many different transitions. People don't know what has happened and what hasn't happened. So looking at the people that are constants and as much as stable people in these kids' lives, I think there's a real responsibility on those people to make sure, even if my kids weren't set up with their special education services, I always made sure that they had contact with the school social worker the first day. This is somebody you can go talk to. That's why I think the guardian ad litem piece is kind of a big focus for education law. I have now been the person in these kids' lives the longest, so I know the most about them, and I'm able to advocate for their educational needs because I know their history. So, I think it's important to really, first and foremost, show those kids the supports at school that they have, because they may have things they need to talk about that's going on at home, in the foster home. So really, identifying those people for those kids first, and then, if problems persist, moving on with the special education.
I'll just add to that, you're exactly right, it's a real problem, and one of the things, it's a really delicate balance from the perspective of guardian or juvenile defense attorney as to when you want to get an identification in school so that a kid doesn't end up with charges because of perhaps situational issues that have happened that have caused behaviors that can be diagnosed. So that's a constant balance that's being done. And juvenile defenders and guardian ad litems often tend to be people who are advocating in the community for more kinds of services in order to stabilize kids in those situations, because you're absolutely right. I mean, it's a totally overstressed system. The money is not flowing into it, so there's not a rich resource pool for defenders and guardian ad litems to draw from to really stabilize the kids. It's a constant problem.
And the other thing to keep in mind too is special education diagnosis doesn't have to last that child's whole life. You could get special education services for 1 year. You could get it for 2 years. So if you're looking at a trauma-based kid, a PTSD kid, that can be, those extra services can be in place just for a limited amount of time. One of the advantages of having an identification for foster children in particular is that the IEP and the services travel with that child wherever they go. So they're going to constantly be required to get those services where they go. So that's an advantage of identification for kiddos like that.
One other issue for you all to spot is truancy. If you're seeing any cases in which truancy is brought up and the parents are being charged with truancy or the kid's not going to school, It's most likely, in most circumstances that I've dealt with, a special education issue, and there's a real concrete reason why that, maybe not concrete, but there is a real reason why that kid is not accessing their education or able to access it. And so I've had several truancy cases where parents have been charged, where the district attorney and the judges are referring the parents to us, because they know it's not, the issue is not the parents not sending them to school and not getting them there. There's another barrier to them accessing the education. So by doing so and referring them to us, the courts and the district attorney's offices know that we're able to help kind of get to the root of what's preventing the student from accessing their education, and we're able to deal with the case from the ground level up, rather than the $250 fine that's going to be imposed upon the parent thinking that's going to solve it. So that's certainly another red flag to recognize if you do have a case involving truancy.
Maine's a pretty small state. How often is your office taking in calls for like new cases, new kids that you're working with? Is it 10 a month, more than that? Is it?
I have no idea.
We do, no, we serve hundreds of clients per year, and we have dozens of clients call per week. More than we can handle, and more professionals calling for consults as well. So hundreds. And Disability Rights Maine is another organization that they're statewide as well. We collaborate with them a lot on cases. They have kind of a different niche of priorities, but very similar special education. We're able to serve a broader range of issues because of our funding, but we work with them as well. And so sometimes we refer to them if the case seems more appropriate for them or for us. But
we also have an income requirement, so
sure.
we only serve low-income individuals. So,
is there, beyond trainings like this, or is there other things that young lawyers or lawyers should be doing to ease the burden on other things? It sounds like pretty overwhelming if you're getting that many calls in such a small office.
we like it.
Well, I mean, if you're interested in this kind of law, we can certainly talk more about what opportunities are available. We have externship programs at Kids Legal in any of the offices where we have attorneys. We also have had fellows in the past, Skadden fellows and Equal Justice Works fellows for students who want to practice special education law out of law school. And volunteer opportunities, certainly there's, in addition to internships and externships, we have volunteer attorneys who donate time to review records and work cases out with us. So there's definitely opportunities and always a need, so don't hesitate to contact us.
Well, thank you guys very much. I'm going to let you go to class because I don't want you to be late. But I have cards, so I'm going to put a couple up here. Has my contact information. If anybody wants the slides, I can email them to Sarah and she will take care of that. You're welcome. Or we'll figure out what we're going to do. So, thank you.